Good afternoon. Welcome to the Court of Appeals. I'm Judge Valerie Zachary. To my right is Judge Jeff Carpenter. To my left is Judge April Wood. To your right are Senior Deputy Clerk Eddie Sanders and Officer Tom Saloon. This afternoon we'll be hearing arguments in State v. Pardo. Counsel, are you ready?
Good afternoon, and may it please the court. I'm Candace Washington. I'm an assistant appellate defender. I'm here representing Mr. Pardo. I would like to reserve 5 minutes of my time for rebuttal. There are public places where we do not intend to abandon our property, and instead we maintain a reasonable expectation of privacy because we have intent to return. For example, when I came in here today, I put my purse and my binder down and stepped out of the courtroom. Surely no officer would be able to come and search my bag and say I abandoned it. Another example, when we go to the beach, we leave our belongings in the sand while we're down in the water. And finally, a woman may go grocery shopping, place her purse in a cart while she's browsing the aisle. And that's the kind of circumstance we have here in Mr. Pardo's case. Mr. Pardo put his bag down when he was shopping at the Best Buy before the police arrived. Mr. Pardo didn't intend to abandon his bag when he stepped away from the kiosk during his $1,300 transaction. He intended to return to the kiosk and his bag, but he was stopped and detained by the police for 40 minutes. There was no voluntary abandonment here. This court should reverse the trial court's order denying the motion to suppress. So since this is a very fact-intensive case, I'm going to start by walking through the facts, and hopefully that will address any of the factual questions you all may have before I get into the arguments. But of course, feel free to move me along if necessary. So as far as the layout of the store, since there's not one single video that shows the layout as a whole, kind of have to piece it together. I'm going to start with that. So if this bench is the front entrance of the store, so you all will be facing inside the store, and I'm standing inside the store facing the entrance, right? So we have the loss prevention office that would be over here to my left. Let's say this is the end of the bench. We have the entrance, maybe where Judge Carpenter is, and then just off to my right from that entrance, there's this first front register that Mr. Pardo was initially sent to, maybe where Judge Zachary is. And then there's a final front register where the search of the bag actually happened. Let's call that at the end of the bench. The cell phone kiosk where Mr. Pardo went to make the purchase was in the middle of the store. Let's say somewhere out here, and then based on the video, it's also like over to the left, right? So that's
approximately where? Where do you think the kiosk would be?
Oh, about how many feet inside?
Yeah, well, behind this and where this gentleman is sitting, or behind?
Definitely further than where this AG is sitting at the table, because there were, like, you could see on the video, there's several shelves in between the entrance and the cell phone kiosk. So, and I'm not good at
front row, you think?
Yeah, let's call it the front row, if I had to estimate, and over to the left. Because if you watch State's Exhibit 2, you can kind of see, because State's Exhibit 2 is the video of the kiosk, and then you can kind of see in the top corner of the screen, you can kind of see where he's like taken to the loss prevention office. So that's how we kind of know it's like off to the left in the middle. So that is kind of the setup of the store. So around 6:42, of course, we know that's when Mr. Pardo and the friend, Miss Lawrence, entered the store. They're going to the cell phone kiosk. 6:56 is when he's putting his bag down in that chair before the police arrive. Of course, you see him take money out in the presence of some Best Buy employee. 6:57 is when he steps away initially, comes back within 2 minutes. He's back by 6:59. 6:59 is also when we have the police arriving. And of course, it seems like this is when Mr. Pardo and Miss Lawrence are aware of the presence of the police, because we can see her at 6:59 taking that gun out of his pants. So she walks off, but Mr. Pardo still remains at the kiosk.
Did the officers remove him from the kiosk?
No,
without his bag?
They don't remove him from the kiosk. So he stays at the kiosk, continuing his purchase while Miss Lawrence leaves. Miss Lawrence gets stopped while Mr. Pardo is still at the kiosk. Mr. Pardo hands the Best Buy employee the money around 7:01. He doesn't have his items yet because the employee is waiting for a counterfeit detection pin. Mr. Pardo doesn't walk away from the kiosk until 7:04. He goes towards the front of the store, and that's when he gets stopped and detained by Officer Millay. And then by 7:05, he's back in that loss prevention office for about 17 minutes.
Was he attempting to leave the store or joining his friend?
That part is unclear in the record. Like, there wasn't any testimony about what he was doing because he gets stopped well before the entrance. Like, he gets stopped before he even gets to that first that first front register where I said about where you're sitting. So the register is in between the entrance and the middle of the store.
So where is he getting stopped? Right in front of me, right here?
Yes, if that's the register, yes. And then of course, like I said, the entrance would be behind you.
Well, he had a significant amount of money in that bag.
Yeah.
Was he prevented from asking someone to go grab his bag for him? Because that's pretty far from that front row all the way up to here. With the, I mean, it was a substantial. I mean, over $100,000, right?
It was like six. I think they only estimated it at 65.
Oh, you're right, 65. Yeah. About $65,000, but that's still a lot of money.
I mean, he wasn't prevented from asking about it because the police obviously didn't know about his bag, but.
I mean, he could have said, "Hey, if that were a woman's purse, it seems like a woman would say, hey, like, officer, let me grab my purse real quick. My purse is over there. Why is this different?"
I mean, maybe, but I don't think that takes away from the argument that he didn't intend to abandon it just because he didn't explicitly make the police aware of his bag. I mean, because
he could have made a Best Buy employee aware of the bag.
I mean, I think it's kind of fair to say, and obviously we don't know what was said to the Best Buy employee, but just watching the surveillance, he's going into the bag in front of the Best Buy employee. So, I mean, and I don't want to obviously speculate because it's not in the record, but it kind of seems like the Best Buy employee knew about the bag. But him not drawing the police attention to the bag doesn't take away from the argument that he didn't intend to abandon it. There's a difference between explicitly wanting to separate yourself from the bag and then just not, like, making the police aware.
So how is that? Would you refer to that as temporary abandonment?
I mean, I wouldn't even call it temporary abandonment, but because he walked away intending to return to it, but and of course, like the case law, we know even if this court did find that he temporarily abandoned it by walking away, if he still had that intent to return, it's not voluntarily abandoned.
Is there any case law recognizing temporary abandonment?
But the Supreme Court case that I cited in my brief, McKinley, says the line, but they don't conduct an analysis. So, like, I didn't find, like, case law in North Carolina that actually conducts the whole intent to return analysis. That's why you see my arguments are like, like a Sixth Circuit case.
Yeah, but doesn't that McKinney case refer to real property?
That one, yeah, it did talk about real property.
So is there any case law relating to personal property?
For North Carolina, I don't believe so, but the case Mulder talked about the intent to return to property, and that was the federal case that I cited in my brief. So in that one, the defendant had checked into a hotel. He left his bag at a hotel, and when he came back, the police, or excuse me, not the police, the hotel staff had already, like, entered his room and turned his bag over to the police. But meanwhile, the defendant had called looking for his bag because obviously it was gone. So he called and asked about his bag, tried to set up a time when he could set it up. But before he could get the bag, the police had already conducted their analysis of the drugs that were found in his bag. So in that case, that court said that he had the intent to return, so he didn't abandon his property.
But isn't the expectation of privacy a little different in your hotel room as opposed to the middle of a store?
I mean, a little bit, but it's still one of these situations where just because it's in the public, that doesn't mean he didn't have the reasonable expectation of privacy. And that's kind of where I hinted at today. Like, I came in here and I dropped my stuff off and stepped out, and surely I had the intent to return, so I didn't abandon it. So it's not like we're automatically saying there's no reasonable expectation of privacy just because we're out in public. And there are a couple of cases that kind of recognize that concept, because obviously there was the Bond case, and that's still a little different. But, that's the case with the bag on the bus. Yeah, it was exposed to the public, but we still had the reasonable expectation of privacy. You don't expect somebody to just go dig into your bag just because it's out in the public. So
the point that we're at right now, though, isn't necessarily the end point of this conversation, right? Because he was then stopped near the registers, taken over to the loss prevention. They talked to him. Through a series of events, they let him know citations were going to be issued. He's there. He's hanging out. there at least 15 minutes. He doesn't go back and pick up his bag. He's there looking at his friend, and then at some point he goes to leave, right? So, I mean, this is a long period of time. This isn't just a few minutes. And then the store employee brings him the bag.
He wasn't going to leave during, like, before he finished paying for the cell phone. So I'm not sure which point you're talking about when you said that.
Well, this is after he's dealt with loss prevention, and they've informed him that they're going to take citations. They're going to hand him citations and give him a court date.
Yeah, but he was still at that front register getting his items when the Best Buy employee came to tell Officer Clark that he left the bag. So he wasn't even leaving yet. And Officer Malay hadn't come back to the store to issue those citations. So he wasn't about to leave before that search occurred. And that's the other thing I kind of want to hit on, because that goes to my whole argument about the fact that he wasn't free to just go about the store. And the trial court's order they kind of excluded that fact, but I guess their way of addressing it was just by saying that he was free to go get the bag. So those facts for why I contend he wasn't free to get the bag was because we have, after he steps out of the loss prevention office with Officer Malay, he still wasn't free to leave because they were still trying to figure out whether they were going to initially charge him or just let him pay that restitution and didn't just be trespass, right? So he's still standing outside the loss prevention office with Officer Lewis at that point, while Officer Malay goes to talk to the Best Buy employee at this first front register where Judge Zachary is, comes back, tells him he can pay restitution, and the Best Buy employee had also informed him that Mr. Pardo didn't finish his transaction. I have his money. So then he sends him directly to that front register to pay, and this register is not on the way to the cell phone kiosk. So if he's being explicitly sent to the front register, he's not going to try to deviate. He's just going to do what the police say so he can go and get on his way. And then, of course, he stands there for about 2 to 3 minutes before Officer Malay comes back over, because Best Buy has then decided that they do want to press charges, so he's going to issue that citation. So he's still not free to leave at that point. And then Officer Malay goes back to the loss prevention office to get Officer Clark and says, hey, go stand with him while I go to the car and do these citations. So then at that point, Officer Clark and Mr. Pardo walk to that furthest register over there where the search occurred, and then she's standing there with him for the 14 minutes before the bag gets brought to the front. So under those circumstances, he wouldn't feel like he could leave. They have the police escorting him. That's not a circumstance where a reasonable person would feel like they could have the opportunity to leave, right? He would have to ask for permission to leave. So he was certainly seized, and like I said, he's still waiting for that citation to be issued. So he's still detained. He's not free to leave the store or free to walk around the store. And in addition to Officer Clark, we had Officer Lewis there as well. He's going in and out of the store, so it's not just one cop. It was a total of 3 police officers, and majority of the time he's with at least 2 of them. So he's not just free to roam around the store even after he was allowed to step out of the loss prevention office. And that goes to, and of course those facts go to my argument challenging the findings of fact for 15, 22, and 26F. So if y'all don't have any more questions about that, I think I hit on most of what I wanted to say for that. And then we already kind of started talking about the intent to abandon the bag, but I had also challenged findings of fact 20, 21, 26B, 26C, 26D, 26G, and those were the findings that were talking about Mr. Pardo intended to abandon his bag, that he did abandon the bag, and that he never evidenced an intent to return.
Does it matter to the analysis that when the bag was brought up front, he then said that that was his bag?
I mean, he said it before the bag was brought as well, but I do think even if you, because of course the trial court didn't put it in the order that he said it before, but even if you just rely on that fact that he said it simultaneous to the search, the bag being brought up, I think it's still important that his claiming ownership of the bag should trump this argument that he abandoned it before the search, because of course we know case law, if you disclaim ownership before the search occurred, the bag is abandoned. Well, here we have it at the same time, so I would think his Fourth Amendment right would trump that, and they should have ceased the search. Because he even claimed it, you know, after she announced her intent that she was going to bag. So right, it's not like he's trying to hide anything. So he's claiming ownership of the bag, knowing what's in it. So I do think that matters. And then, so yeah, the intent to return. This isn't a case where he's seeing the police and actively separating himself from the bag by putting it down as a result of seeing the police. Because like I said in the beginning, he was shopping. He put his bag down before the police ever got involved. And then when he saw the police arrive, he offloaded that gun, but he didn't try to send that bag out of the store with Miss Lawrence. He stayed at the register and continued with his transaction. For whatever reason, he walked to the front during the middle of that transaction. The items that he was purchasing, he hadn't even received because they were still behind that register. And of course, like I said, the Best Buy employee was waiting for that counterfeit detection pin. So he's clearly trying to come back to the kiosk if he hadn't finished processing his transaction. And we know that by the end, he did finish that transaction because he was allowed to pay for his items and pay for that restitution. So he had that intent to return. And then findings of fact 23 and 26E were about the clerk safekeeping the bag. The trial court found that Mr. Pardo didn't ask the clerk or anybody to watch his bag before he walked away from the kiosk. I contend that that's not supported by the evidence because there was no testimony to that effect. And you'll see that the surveillance video in State's Exhibit 2 didn't have any audio, so there's nothing to support that finding of fact in the record.
If Mr. Pardo's bag is picked up by the clerk, not opened, placed in lost and found, does Mr. Pardo still have a reasonable expectation of privacy in the bag?
Before he leaves the store?
We hadn't got there yet.
Okay, so I'm going to say, assuming that all the other facts remain the same.
You're wanting to add facts to my hypothetical.
Well, that's what I was
And
clarifying.
I'll let you in a minute, but answer the first hypothetical first. If he's there, he leaves the bag, it gets placed in lost and found, does he have a reasonable expectation of privacy?
Yes.
He does?
Yes, because he still has the intent to return.
How do we know that?
This is what I was saying, assuming the facts are the same. He walked away from the bag in the middle of that transaction.
So we're getting to the meat of the case here. How do we know he had the intent to return here?
In my case?
Yes.
Yeah, he stepped away from the kiosk in the middle of his transaction, so he's obviously going to come back to pick up the phone that he went to purchase and retrieve the bag. He didn't even walk out of the store. I think that would make a difference as far as whether he was intending to abandon the bag versus come back and grab the bag.
So we don't know whether he was intending to come back and get the bag or not. There's an inference to be drawn from the facts that could have been the case, but couldn't the same inference be drawn that he intended to walk away from the bag knowing what was in it and the police were there?
Well, that's what the trial court did, that's what the trial court is inferring, but that's why we can argue that he did intend to return to the bag because he left in the middle of that transaction. We already saw him put the bag down at the 6:56. I said he stepped away from the kiosk at 6:57 and he returned back at 6:59. So he's not like walking off and trying to leave his bag. He went there to purchase the cell phone. He handed over the $1,300 and didn't get the items that he paid for. And the trial court kind of relied on, the trial court's inference that he intended the bag was partially based on the fact that, what did it say? That he filled out the affidavit that he was indigent, so surely he wouldn't have forgotten it. Well, he wouldn't just waste the $1,300 if he was indigent, so that's kind of like the same type of thing. We're building inferences off of the objective facts in the case, so that's why we can infer that he had the intent to return to the bag based on what happened. He left during the middle of that transaction, and that's like the key for this case. We don't really have anything else to point to.
So the bag gets picked up, put in lost and found,
Okay.
and he doesn't return. When does the expectation of privacy go away?
If he doesn't return, I'm assuming you're meaning he's left the store. So at that point,
You're adding facts to my hypo, and we're not there yet.
okay.
My question is, if it gets picked up, it's a little different than what we have here, but if it gets picked up by a clerk, put in lost and found, you told me earlier that he still has an expectation of privacy because he has an intent to return. How long does that last? How long does the intent to return last before he's not returning? It's just abandoned the property.
I wouldn't say there's a time limit on it, and I don't think the Mulder case, I don't even think the Mulder case happened in the same day as far as him leaving the hotel staff entering the room and finding the bag and him calling back for it. So I don't think there's a time limit on it. That's why I was saying, I think if it was picked up, placed and lost or found, and he would have left the store, then that's more of the argument that he obviously intended to abandon the bag. Like, I wouldn't think there was a specific time limit. I would say if he left the store and never returned, maybe even if he left the store and called back and said, hey, I forgot my bag, and that's still, changing the circumstances. It's not, I don't think there's like a one specific rule that we can narrow it down to.
Did Mr. Pardo need to have the intent to abandon or just the intent to return?
He needed the intent to abandon for it to actually be considered voluntarily abandoned.
In your brief, you say, Mr. Pardo walked to the front of the store toward Officer Milley. Officer Milley stopped Mr. Pardo. Was Mr. Pardo attempting to leave the store?
That I cannot say. That was not put in the record. I don't know if he was going to check on Ms. Lawrence, because I know Ms. Lawrence got stopped. You can see it on, I think it's Officer Malay's body cam. You can see that Ms. Lawrence made it out the door before she got stopped, so I don't know if we're going to assume that he was going to check on Ms. Lawrence or what, but that, like, those specific facts about where he was actually going weren't put on the record by anybody. And he didn't talk about where he was going when he was stopped. So we're into this. Yeah, I feel like I hit on most of this already. We already got into the legal argument as to why I said the bag wasn't voluntarily abandoned. And I just want to reiterate, like I said earlier, and of course we know the trial court made the finding of fact that Mr. Pardo claimed the bag simultaneous to the search, during the search, but he did also claim ownership of that bag before it was even brought to the front of the store. You can see around in Officer Lewis's body camera, around the 37-minute and 55-second mark, there's this whole discussion about the bag that Ms. Clark, Officer Clark, learned about the bag from a Best Buy employee. Mr. Pardo is saying, yeah, it's over there, so he's acknowledging the bag. Officer Lewis is asking Ms. Lawrence if she wants to show him where the bag is. She's shaking her head and saying it's Mr. Pardo's bag. Around 38:02 is when Officer Lewis asked Mr. Pardo if the bag was his, before the bag was even brought to the front of the store. You see him nod his head. And then, of course, I reiterated earlier that
Well, wasn't he, though, standing there with one of the officers when the Best Buy employee came up and said, hey, here's his bag?
Yeah.
You know what I mean? So, and I guess, when he knows that the employee already knows that it's his bag and that there's video footage of him with the bag, wouldn't it be kind of difficult for him to deny ownership of it at that point?
I mean, it would be difficult for them to believe him, but people deny owning the stuff all the time. So I don't think that changes the analysis. He claimed the ownership of the bag. And then just want to hit on the fact that he wasn't able to go get the bag because he was detained that whole time, from the time he was initially stopped around 7:04 when he walked away till 7:44 when that bag was brought to the front of the store. And I think I'm going to run up on my rebuttal time, so I'm just going to...
You got 1 minute and 50 seconds left, so I have a question for you.
Okay.
Who has the burden to show, is it the state's burden to show that Mr. Pardo abandoned, or is it your burden to show that Mr. Pardo did not abandon?
I believe it's the state's burden, because once you do the motion to suppress, the state puts on the evidence to prove that the motion should be denied. So the state would have the burden to prove that he did, abandon the bag.
Okay.
And is the evidence viewed in the light most favorable to the defendant or to the state?
I believe it's the state.
Do you have any further questions?
No, ma'am. Thank you.
Do you have any further questions? Thank you.
May it please the court. My name is John Payne from the Attorney General's office. I'm here representing the state in this matter, State v. Pardo. But also like to, I have with me half of the DOJ interns who I have not all met. And I hope that they learn from this, that they too can get up here and have this case, but I hope they don't feel too confident after I'm done. I think Ms. Washington has identified correctly this is a fact-specific issue. This is really about abandonment. And I think the trial court got it right when they did find abandonment. And the quick facts before I get to the test are defendant comes into a store, and what we haven't spoken already, he and his partner, Emily Lawrence, have been caught on videotape 3 days earlier stealing from the store. They have video shoving in their pockets. He also has a weapon in his back pocket. So when he is at this kiosk in the middle of the store, police presence, we know, come in around 6:58, 6:57. That is when he has a discussion, probably off camera with Miss Lawrence. She does come up to him right before 7 o'clock and shows in the video, she reaches in his back pocket and takes out the gun. And she testifies to that. Why did she do that? Because he knew the police were there. This is his first test. She walks to the front of the store, and he is intermittently watching her go from this kiosk. She is detained by police. I don't know whether she's trying to get out or not. Probably her test case. So what does he do? By 7:04, he looks around. He's done a little bit of payment. They're looking with the employee from Best Buy who's on the other side of the kiosk. Maybe if I'm at the kiosk right here, it's pretty small, right? And the defendant has taken his bag, this camera bag where he has his goodies, and he has put it in a chair. There's 2 drinks right here. He's put it in a chair, and he has scooted it sort of halfway underneath. It's still in the middle of a public place. She walks out, 7:04, he walks away. And this is where I say he has abandoned the bag. Because in a police presence, what does that bag have in it? $65,000 cash. It also has 2.5 pounds of marijuana and 43 milligrams of meth. He does not want to be caught with that bag. He leaves that bag. I say this case is like a drug case where people get rid of the bag. Instead of throwing it, he voluntarily walks away. We understand his intent to leave it because who in their right mind leaves $65,000?
Why do you think he slid the chair back up under the chair with the camera bag?
I think
up under the desk.
I think it's a good question, Judge Gardner. When he has to get money out of that bag to pay for his cell phone, and he is pretty much over it, pretty hunched over. I don't think he wants a camera to see what's in that bag. So that's why I think he does that. Is it material to this case? I'm not sure.
If he's abandoning it, why does he care?
Why does he care that it's...
That a camera sees what's in the bag, he's walking away from it.
Oh, he didn't want to... I don't think he came in with the intent to abandon it.
When do you think that intent arose?
When he saw police.
Was that after he had sort of slid it back up under the desk to, for lack of a better term, conceal it?
I think he always kept that bag pretty tight in that chair. When he's getting money out of it, he zips it up. He's pretty careful. I don't think he wants that employee to see what's in there, besides cash or marijuana. The marijuana was vacuum sealed in there, and part of the cash was too. But I think his intent is shown when he leaves. First of all, he gives his gun away because he knows police are there. Second of all, he loses his reasonable expectation in privacy when he walks away.
Does property have to be abandoned at the time of the search?
At the time of the search, no. It does not. It can be before, like in a drug case, Judge Zachary, if they throw it,
And then it's abandoned.
if you voluntarily do that, it's abandoned,
Right.
right? That's what,
But then what if you tell the police, well, I mean, I shouldn't have thrown that. That's my bag. Please don't search it. Has he reclaimed ownership then?
right.
Is it no longer abandoned?
If you voluntarily throw it, you do abandon it. When can you re-abandon it? I mean, when can you regain your reasonable expectation of privacy?
That's the question. Can he regain a reasonable expectation?
Okay, because and you can regain your property, Judge Wood, but I would say you have lost your reasonable expectation of privacy if you throw it out in a public space. Anybody could come do it. If I lose my wallet in a public space and I come up and I leave it somewhere, what is the first thing somebody does? Do I reasonably think that nobody's going to look at my wallet?
But did you then abandon it if you lost it?
Well, if I have the intent to do so, right? If I have drugs in there and the police are coming and I throw it because I don't want them to see it, I think that is different than this case. That's why I do analogize to the drug cases as opposed to just leaving something somewhere.
What's your response to the theory of temporary abandonment?
That is a tough question. I do understand that, and we did our moot court, and we all struggle with that, right? There's not that in the state of North Carolina. One thing I would like to mention is defendant never discussed that they ever temporarily abandoned this. They've always said it was not abandoned. And therefore, at that suppression trial, they never went into, did you regain it? However, I am going to answer your question, or try to, Judge Zachary. I think you do have to show some intent to regain back possession and a reasonable expectation of privacy. And in this case, even if you take that, even if you say he reasonably, or he's trying to get it back, he temporarily abandoned, what did he do? Does he show the intent to regain possession? He does not want to do that. When he has brought that bag, or the bag is brought by the employee for Best Buy after 40 minutes, and the police get it, and they look at him and say, is this your bag? What I have briefed is he whispered in the ear of Emily Lawrence, O-F-U-C blank. He doesn't say, thank God you found my $65,000.
So intent is generally shown by circumstantial evidence. So is that the argument that you're making now, that the circumstantial evidence shows his intent to abandon the property?
I am, and that was the Eaton test. I believe it's a 2011 case drafted and issued by Judge Stroud that said if you voluntarily leave a possession and it's the police presence is legal and it's voluntary and you can show that, then you have voluntary abandonment. I also would like to add that I did find a Fourth Circuit case, U.S. v. Small, I believe it was, and they said they added to that, and they say, we'll look at the actions and words spoken to find intent. And if you look at that in this case, we don't find, as you identified earlier, he never asked back for his bag. He could have. Whether he was detained or not, he had a lot of chances to. Did he have opportunity to go there? We were talking about the distance from where he was at the register. He could have. But at a minimum, he could have said, when he was going there, officer, can I go get my bag? He didn't do that. He showed absolutely no intention to regain this bag because he didn't want the bag, because it had drugs. They were going to check him. They took him to the Loss Prevention Center and basically checked his body, see if he had anything. He didn't have anything. So he knew what he was doing. He intentionally abandoned that. You do, I think, the state maintains, you do have enough evidence to show that.
But then when they brought the bag, I mean, he claimed a bag. He says, it's my bag. And the officer says, is there anything in there that's going to poke me? And he goes, no, not that I know of. The officer says, not that you know of. It's your bag. You know exactly what's in there. and then searches the bag? Why did the officer not have to ask for permission to search the bag?
First of all, I say he acknowledged the bag was his by nodding. He didn't say, may I have the bag back, right? That might be a better situation where it makes it more difficult for the police because the bag at that point had been abandoned. So if it's abandoned, they still have the ability to look at it. So, Judge, what if he grabs that bag back? He says, give it to me. I want it. Don't open it. Which was the case in Mulder, even though that was a real property case, but the man left his hotel, they found his bag, it had drugs in it. Before the police searched it, he said, I want my bag back. He showed some intention to get that bag, to have it, not to abandon. And he didn't show any here. There was just no evidence of that. I think defendant said he showed that because he didn't give Miss Lawrence the gun and the bag. I don't know if that's relevant. He also gave $1,300, and he didn't want to abandon that. I don't think that's valid either. I think he didn't want to go to prison. He didn't want him to find that. And he knew he would have because he already realized he was a felon. He already realized he had a gun. And he realized he had cash and drugs in that bag. And he realized that they were going to go ahead and search him for that.
In this case, Mr. Pardo obviously knew he had the bag because he had gone in and retrieved money, correct?
Correct.
He knew the bag was in the chair. He got up and walked away from the chair. Assuming we find, okay, he's abandoned it. At the time when the bag's brought back over to the officer in Mr. Pardo's presence and he says, that's my bag, talk to me about whether or not that he's now acknowledged the bag, whether he we're assuming, we're agreed for argument's sake, we're assuming you've convinced us he abandoned the bag in the interim, but now he's reclaimed it. Why does he not regain the reasonable expectation of privacy at that point? And I'm not asking the question with a presupposed answer at the end. It's a legitimate question. I want to hear your thoughts.
So I sort of reason, Judge Carpenter, to if the police are out and he throws a bag of, they're about to arrest him, he throws a bag of drugs on the ground. You have voluntarily abandoned your reasonable expectation of right of privacy, right? I have given that away. Can that person then say right before, and the cop goes and picks this up and says, what is this? Uh-oh, that's mine, give it back, you can't check it. It does make a better case for a defendant if they show some intent to retain their expectation of privacy and possession.
We're not there.
Okay.
We bought your argument that he's abandoned it.
Yeah.
So it's not about retaining, it's about regaining.
About regaining, what's regaining? There's very little case law on that. There's not in North Carolina.
I'm aware of that.
Yeah.
That's why I'm asking you the hard question.
That's why we're asking the
It was hard for me. I know. I was like, please don't ask me that. I knew you were going to ask me that question.
And that's exactly why you're here today, sir.
Yeah. Well, I would say, I think there was an argument to say that argument was waived because they always say that they abandoned it. They never said they reclaimed it. So, it wasn't fleshed out at that suppression hearing. We never got to say how much did it. No, so then we look at the facts here. Do we see any intent? You have either an intent to never abandon or you have an intent to reclaim. He never even showed, and so to answer your question, I think the best of my knowledge, if I was having to write this case, is that you have to show some intent to regain the property, which he did not do. An acknowledgement is not an intent to regain. And then you have to, and maybe you have to have possession, but at a minimum, you have to say, that is mine. I don't want you to check it. You have to do something after you abandon it, if that argument has been accepted.
Let me ask you this question. Say, Mr. Pardo, we bought your argument, okay?
Okay.
This is for argument's sake. You've won the initial argument. Mr. Pardo has abandoned the bag.
Okay.
When the clerk picks it up, why is it not the clerk's bag?
Well, the clerk doesn't have possession. The clerk doesn't gain
Sure he does. The
possession.
clerk walked it over to the police officer.
But it's still not the clerk's.
Was I wrong all those years when DAs were talking to me about possessive and actual and constructive possession? Clerk has actual possession of the bag.
They
If it's
do have
abandoned
actual
property.
possession of property, but if I drop my wallet, that doesn't mean somebody can pick it up and keep it.
Depends
right?
on whether you intentionally abandon it.
Yeah, I would agree to that. If I left it, then they could. If I still want to retain possession, I will look at them and say, Judge Carpenter, that's my wallet. Can I have it back? That's mine. If I voluntarily abandon it, I don't ever want to get it again.
But in order for you to get there, the state had to show that there was an intent to abandon the property.
That's correct.
If there was an intent to abandon the property and the clerk picks it up, why is it not the clerk?
Well, we look at, why is it not the clerk's in their possession? First of all, they probably don't want the marijuana.
The clerk doesn't know. The clerk knows. He just knows he's got a bag. And with $65,000 in there, he may run the risk. Who knows?
I don't know if you can claim possession of somebody else's property.
Well, that's the point. Is it somebody else's property if it's abandoned? Or is it nobody else's property if it's abandoned, therefore it's anybody else's property who claims it?
Well, if you abandon it, maybe it's anybody's property,
Well,
right?
That's
Before you reclaim it, so maybe you
Ms. Wallace?
Yeah.
Ms. Wallace, pay attention. We're going to talk about this in a minute. So
potentially that could be somebody else's property if you abandon it.
I don't know. It's an interesting fact scenario in this case.
And so if I had a ball and I don't want it anymore, and I go, let's say basketball, and I just leave it at a park, and I voluntarily abandon it, and somebody picks it up, is it theirs? If I voluntarily abandon it, yeah, it's not. They can take that ball.
But if you come back and want your ball back, then you didn't voluntarily abandon it.
After they've gained possession?
Is that what Mr. Pardo did here when he said, that's my bag?
You're saying, did he regain possession after that?
No, I'm saying if by him saying, yes, that's my bag, was there never the intent to abandon in the first place?
No, I don't think so. First of all, it was an acknowledgement.
Okay, I like your answer. Why?
Why is it not?
Yep.
Because he showed no
The
intent.
why was always the hard question in law school, right?
Yeah, it is now too. As I was trying to explain to Judge Wood, his acknowledgement that it's his is not the same as regaining.
Ms. Wallace's argument is that he never intended to abandon it. The reason you know that, judges, is because he claimed the bag after the fact. That's how you know. If he'd intended to abandon it, he would have not claimed the bag. I think I've paraphrased Ms. Wallace.
Okay. I guess my answer to that would be
Ms. Washington, I'm sorry.
that erases all of his actions to abandon that bag. His walking away from it, leaving a huge sum in a public space where anybody, you can see even in the videos, people just walking by. Eventually the employees found it. They didn't see it at first, but eventually they obviously did. But he could have just lost. Do you lose the right to that money? Let's just say it was money or a bag. Not if you don't voluntarily abandon it, but if you do voluntarily abandon it, then you lose. I think you lose that right to it.
And it's whoever gets their hands on it first.
If you voluntarily do that, can you ask for something back? Hey, that's mine. I left my ball out here, but I want it back. You left it. I get it. Sorry, too late. So that's probably how I would answer that. But it's a very difficult question to answer.
That's why you're here.
Yes. A couple other facts that I would like to emphasize too are when we talk about detained for him being detained, and I'm only repeating what Judge Eicher said, he still had the ability to ask for my bag back. That this is 40 minutes total. You don't ask to get $65,000 back. It seems unreasonable, and that's what the trial court found too. And even if you want to look for his detainment, one piece of his intention that the trial court found was, was he able to go get it, right? And we talked about the space and how far. I might think it's a little closer, maybe 10, 15 feet, if you look at the video. I admit it's a little difficult to figure out, but the testimony from Officer Lewis was that he could have, within seconds, he would have gone to get his bag. So what happened was defendant went to the Loss Prevention Center. Was he trying to leave the store? I don't know about that either. I'm sure he would have if he could have, but he was definitely stopped. He went to the Loss Detention Center. After that, when he came out of that Loss Prevention Center, I want to emphasize that they didn't find anything on him. All they had was a video. They said, we're going to give you a citation. They were more interested in Miss Lawrence because she had the gun. So Officer Malaya, after speaking to him, not finding any contraband on him, he said, hey, do you want to go over here and pay for your cell phone and these other items that you stole? And defendant said, yeah, okay, I'll do that. So one piece of the intent, too, when we're talking about whether he had the opportunity to go get his bag, he was not escorted by anyone. The police weren't really even looking at him. He wasn't under arrest. And the bag was
At that point, he was no longer detained.
At that point, he was
at least not in close proximity. He was free to walk around the store.
Yes, he was free to walk. And that's the testimony. And the bag was pretty close to where he was. And he stood over there, and you can see him in the video. He's just standing like this for about 10 minutes, just waiting for somebody. But he never asked an employee to go get that bag. And Officer Malaya even asked him, do you have enough money to pay? So that should have been a trigger. Oh, yeah, well, most of my money, $65,000, is in my bag. Can I go get that? I mean, I think that intention is clear. I think his reaction when he gets the bag is clear that he never wanted that bag back. Not at all. I don't think he showed any intent to get it. So, and I think whether he was seized or whether he was not seized, I think that's just part of the equation to whether or not he had opportunity to ask for the bag. You know, even when he left that kiosk, he never asked the employee, can you safekeep this for me? Can you, whether or not there was just so many factors that show he had no intention. He didn't want to be found. He had drugs in the bag, and he didn't want to be found with police with that bag on him. I would like to say, I think we already identified that in reviewing these findings of facts and conclusions of law, if we do have competent evidence, we are bound by the trial court's findings. And it is, as Judge Wood mentioned, it is in the light most favorable to the state. And I think we do have competent evidence in all these findings of fact. Let's see if there's any that we really need to discuss. One thing I would like to say is that the two cases I think I would rely on are Cromartie and Eaton. And Eaton does provide that test about abandonment. They are two drug cases. It's when you leave or throw or have some voluntary action. And I would look at those as pretty similar. I think the ones that defendant has brought forth, none of those fit this fact pattern. You didn't have illegal police activity. You didn't show an intent to return. So I guess I would finish by saying I think the trial court was correctly found, and I think the evidence shows that defendant abandoned the bag, never intended to come back, and loses his right for the reasonable expectation of privacy. And anybody who leaves a bag in a public place cannot reasonably expect that somebody won't go through that bag. You may still get that bag back. You may retain possession. But while it's out there in the public, you lose that right to privacy. And if I will entertain any more questions, I have a little time left, but if not, the state will rest. And thank you all.
Well, in the court order, the court says, defendant at the time in question intended to abandon the camera bag containing contraband. What's the time in question? Is that at the time of the search, or?
I think it's
That
right away.
day?
I think right when they walked away, Judge Zachary, right when he saw police and left that bag is when he abandoned it. I think everything else shows his intention. And I think that's why the court went through the exercise of looking through all the factors that can support his abandonment.
Thank you.
All right.
Do you have any further questions?
No, ma'am.
Any further questions? Okay, thank you, sir.
Thank you.
Okay, couple of points. So earlier, I think it was Judge Carpenter was asking me about how do we know they had the intent to return. So I just wanted to reiterate that the case law in the brief, that's what talks about, we have the factors for the intent to return, the words spoken, the acts done, and any other objective facts. So that's why it is relevant that Mr. Pardo didn't give Ms. Lawrence his bag when he sent the gun out of the store, and the fact that he was in the middle of that transaction when he stepped away. So that's all relevant to that. And then a couple other things just based on what the state was saying. And I think I did a pretty good job of laying out the factual details in the brief, but so I'm just gonna move through these really quickly unless y'all have questions. The bag was not slid under the desk in that chair. You can see that the bag is visible on the camera in State's Exhibit 2. He wasn't standing at the register for 10 minutes. He was only standing by himself for about 3 minutes before Officer Millay sent Officer Clark to stand with him at that furthest register. So he was not standing at any register by himself for 10 minutes. And then the biggest thing I wanted to focus on was you all were talking about this hypothetical of if a defendant is stopped by the police and he's fleeing and then he discards his property. Can you then claim ownership when the police come and pick it up? That is a completely different scenario from this case. That is like all the other type of abandonment cases where we see the defendant is abandoning the property as a result of seeing the police. In this case, the property was already placed down before he saw the police. So he's not trying to separate himself by putting the bag down as a result of seeing the police. The bag was already placed down. And of course, I've beat this over the head many times, but then he walked away from the bag in the middle of the transaction for who knows what reason. So that's like a big distinction when we're talking about that voluntarily abandonment aspect. If you look at all the abandonment cases, it's that type of thing. They're abandoning the property, putting it down, fleeing as a result of seeing the police versus what we have here, where he's just putting the bag down while he's shopping. And then I think that's most of my rebuttal points for you guys. So I'll wrap up unless you guys had any more questions. But of course, we're here because this is, oh, sorry, were you about to?
I did, yes, ma'am. So, back to the conversation I was having with Mr. Payne. Say we buy the argument. He's abandoned it, walked away. Can he regain his right to privacy, a reasonable expectation of privacy, by reclaiming it? It's different. I agree with you. It's different than factually than tossing something away as you're trying to flee a scene. But in this case, he voluntarily got up and separated himself from the bag. It was brought back over. Can he reclaim the right to privacy, the reasonable expectation of privacy?
Yes, because he claimed, and that's the key thing here, the fact that he claimed it before the search occurred, because property has to be abandoned, at the time of the search. So by claiming ownership of the bag before the search happened, he's obviously asserting that reasonable expectation of privacy before the search occurred. If he would have obviously claimed it after the search, then that's two different things. So that hits on what I think it might have been Judge Zachary was asking if the property had to be abandoned at the time of the search, and it does.
Okay.
So of course, we're here because we know this is a unique set of facts, and it's quite the opposite from what we see in abandonment cases. As I was saying earlier, he wasn't fleeing from the police and putting the bag down and running away and trying to separate himself in that way. It's clear he just...
He may have been. Didn't you concede that he may have been trying to leave the store?
I don't know if I said that. I might have, but we don't know, so I don't think that matters as far as...
Because he was
This
walking
case-
toward the exit.
Yeah, that's all we know, that he was walking
He left the
towards...
bag. After he saw the police, he left the bag and he was walking toward the exit.
Yeah, the court found he was walking toward the front of the store when he was stopped and detained by Officer Millay. So we don't know if he was leaving the store. That the trial court didn't make that finding, but we do know that he stepped away in the middle of that transaction. Of course, that goes to my argument that he had the intent to return to that bag. He claimed ownership of the bag. He never disclaimed ownership of the bag, which is what we typically see in abandonment cases. And he did not put the bag down and flee as a result of seeing the police. And I think that's the key distinction here. He put the bag down while he was shopping, stepped away, came back to it, and didn't try to leave as soon as he saw the police. He stayed and continued his transaction. So this is not a case of voluntary abandonment, and Mr. Pardo never intended to abandon the bag. He claimed that bag even after Officer Clark announced her intent to conduct that illegal search of the bag. So we contend the trial court erred by denying Mr. Pardo's motion to suppress, and we ask that this court reverse. Thank you.
Thank you. Any further questions? Thank you very much. That concludes oral argument in this matter. We'll take it under advisement. This is a tough case. Thank you, counsel, for your excellent arguments.